Hello, and welcome to Working Wise, a podcast created and produced by K&L Gates. This episode of Working Wise is recorded in collaboration with Triage, a K&L Gates podcast that discusses the latest developments in health law. We hope you enjoy this episode.
Hello. During our discussion today, we're going to talk about employment law, the healthcare sector, and how they intersect. We're going to do that by discussing the 2021 year in review, as well as developments that will impact both sectors in 2022. I am Lou Patalano of counsel in K&L Gates, RTP North Carolina office, and a member of the Healthcare FDA practice group. I have the distinct privilege of speaking with two of my esteemed colleagues today. First, allow me to introduce you to Jackie Hoffman, a partner in our firm's Dallas, Texas office, and a member of the Healthcare FDA practice group. Hi, Jackie.
Hi, Lou.
Next, allow me to introduce you to Spencer Hamer, a partner in our firm's Orange County, California office and a member of the Labor, Employment, and Workplace Safety Practice Group. Hi, Spencer.
Hi, Lou. Thanks for the introduction.
Spencer is one of the authors, and Jackie was a contributor to our firm's 2021 Healthcare Employment Law Year in Review. Spencer and Jackie, I thought that we might begin our conversation today by talking about some of the issues that were highlighted in that article, and then move towards taking a look into the crystal ball for your forecast for the remainder of 2022. Unfortunately, when we look back at 2021, we cannot ignore that COVID-19 is still having a lasting impact on both the employment and healthcare sectors. So Spencer and Jackie, if it's okay with you, maybe we can touch on COVID-19's impact on 2021 and 2022. Then we can quickly pivot to other areas that may be of interest to those like us suffering from COVID-19 fatigue. So Spencer and Jackie, let's start with vaccine mandates. Where do you want to begin?
Well, why don't I start with a little bit of a recap? I know that last year I had the good fortune to have this conversation with Spencer, and we talked about 2020, and we forecasted or hoped that there'd be a lot of non-COVID related activity we could look forward to. And as you mentioned, Lou, quite the reverse happened. We stayed fairly well embedded, but that by no means should suggest that our worlds were stagnant. And in fact, particularly in the area of COVID vaccines that became available in the beginning of 2020, we've seen a lot of activity in the healthcare space and the labor and employment space. For those who've had the opportunity to take a look at the year in review article, you'll notice that it has a robust summary of state-by-state summaries that relate to vaccine mandates occurring starting in the summer of last year. You'll see that Colorado and California, Illinois, Delaware, New York, and others started to implement their own mandates relating to healthcare workers who needed to be vaccinated to be taking care of vulnerable populations in hospitals and nursing homes. But in November, the federal government tried to make vaccine mandates in the healthcare setting and elsewhere more uniform through a variety of rulemaking efforts. First, there was the OSHA Emergency Temporary Standard that was an attempt to implement vaccination requirements in employment settings of 100 employees or more. There was a federal contractor mandate by which the federal government tried to insert or effect a mandate through its own contracting procedures. And lastly, there was a CMS mandate in the form of an interim final rule that would impose vaccine mandates in the healthcare setting for healthcare workers. So through this variety of rulemaking and implementation efforts, we found ourselves trying to tease apart these different requirements and how they apply to our respective clients at the end of the year. I'm going to jump a little bit to 2021 because it's relevant in that the Supreme Court took up the issue of the vaccine mandates that I just described, trying to put, again, some uniformity around their interpretation and their implementation. And in doing so, and we'll talk a little bit about what to expect later, the Supreme Court found that the OSHA mandate was not enforceable. In fact, of the three, the only one that clearly remained enforceable and is right now is the CMS vaccine mandate for Medicare, Medicaid providers and their healthcare workers. And so right now, based on timelines that were set back in 2021, healthcare settings are working to hit timelines that were set out in advance of the Supreme Court ruling as to when employees had to either be fully vaccinated or had gotten an acceptable exemption. I want to wrap it up there just with a heads up or a warning to our clients that as a result of all of the lower court activity at the very end of 2021 and the Supreme Court's ruling in the beginning of 2022, we ended up with 3 tranches of states that each had different timelines. So let me end there with just a reminder that make sure you know which timelines apply to you and make sure that you know what you need to do at each timeline in terms of demonstrating the percentage of employees who are fully vaccinated and or have gotten exemptions. And with that, I will turn it over to Spencer.
Yeah, thanks, Jackie. That's a great summary. And we're going to be watching in 2022 as employees return to the workforce, continued obligations of employers to potentially accommodate religious and medical exemptions for these vaccine mandates for healthcare workers. So that's been an ongoing issue throughout the pandemic, but we anticipate continuing to see that as an issue in 2022.
So, Spencer, lots being published about staffing shortages, burnout, and the great resignation. What advice might you offer our clients in these areas?
Yeah, that's a good question. We have seen employers struggle, obviously, throughout the country in all industries to retain workers, but it's been particularly acute in the healthcare setting. And a lot of this goes back to culture. Have you built the right culture within your organization? Do employees feel valued? Do they feel heard? Do they have the resources to perform the job? It's not necessarily always about compensation. They need to be onboarded properly. For example, if you're bringing in new hires, are they getting the right training? Do they know what their job duties are? Do they know who to bring issues to? If you have a mix of remote and in-person workers, do the remote workers feel like they're being treated fairly? Do they have the right resources? Oftentimes, they're the ones who might not be getting the full attention that the people back coming in on a day-to-day basis are getting. And what about fairness? If you have some people who are making some requests, for example, to work remotely, maybe permanently or part-time, is that being handled consistently across your organization? Is there somebody who's a single point person for handling those kind of issues to head off claims of unfair treatment, for example? So there's a lot of challenges, obviously, with trying to keep employees engaged and understanding that they are a valued part of the workplace culture. But the more time and effort employers put into that, particularly on the front end, it's going to pay off for them.
Thanks, Spencer. So before we move away from talking about COVID-19, and I promise we'll move away from talking about COVID-19, one of the topics that we touched upon in the article was COVID-19 whistleblowers. Spencer, what have you seen in the term of whistleblower litigation in the healthcare sector during COVID-19? Any trends?
Yeah, this has been an area that we've been watching closely from an employment standpoint, representing employers and particularly healthcare employers. I think it's still a little early to predict trends as to how courts, juries, arbitrators are ruling on these kinds of claims. However, there's been a significant number of them. Currently, OSHA has recorded 6,572 whistleblower complaints since COVID started. And the data suggests that the whistleblower claims are most commonly brought against employers in the healthcare industry. Not only do employees bring claims about their own safety or their coworkers, but in the healthcare industry, they can bring them about patient safety as well. So it just brings more opportunity. But we'll continue to monitor this to see if we see a pattern in terms of how these rulings or cases come out. It'll also be interesting as employees return to in-person work. Will we see a sort of a change in how these complaints arise? Or are they going to start to come down once the COVID case count comes down? Or maybe they're going to continue to stay steady for a while just because people are coming back into the workplace and potentially raising complaints that they might not have raised if they were working from home. All that being said, it's just critical, as it has been throughout the pandemic, for healthcare employers to have a strong compliance program in terms of health and safety in the workplace at both the federal level and if they have their own state-specific laws that are counterparts to OSHA. continuing to train, continuing to update those policies. And also, when they do get whistleblower complaints, it's critical that they have a process for receiving those complaints, responding to them, investigating them, and documenting all that appropriately.
And Spencer, you talked a little bit about compliance, but in this new remote working world, how have you found remote working impacting conducting investigations into areas such as whistleblowing complaints?
Yeah, I think some employers have felt it's a little challenging when they're conducting these remote investigations. For example, when you're interviewing someone in an investigation, one of the things you have to do is evaluate credibility. I think we've all sort of seen studies or commentary on how do we interact with one another online or on Zoom, for example, versus in person. There's all kinds of nonverbal cues that might not get picked up online. So these things are really important in an investigation and can ultimately be potentially a hurdle to overcome in terms of certain aspects of the investigation. That being said, the obligation for employers to investigate remains, and they have to go ahead and conduct these even with remote workers and scheduling interviews online.
Thanks, Spencer. So turning slightly away from COVID-19, as I promised we would, the Biden administration and the U.S. Department of Justice made some headlines in 2021 with a stated position on non-competes and their enforceability. So, Jackie, if you don't mind jumping in, how should employers be thinking about DOJ's and the Biden administration's position on non-competes? And what advice would you give to our clients?
Well, I think that it's an area that both of our areas of specialty, Spencer's and ours, have talked about and struggled with over time. We've seen historically regional differences, and we've seen the pendulum swing on how the federal government views them as well. And I think that what's really important is to be cognizant of what's happening in both your area and the nature of the agreement that your organization is trying to enforce, or conversely trying to demonstrate is unenforceable. And given the weight of the government stated position on enforcement, what is the best course of action for you to pursue? I think I'm going to punt a little bit to Spencer on this one, because I do think that he is seeing it in his area of practice much more than we do. We do occasionally, and have in the past, had this discussion around the mobility of professionals who find themselves dealing with non-solicitation language and a general historical position that they don't apply or shouldn't be allowed to be used to limit professionals exercising their rights to practice their profession.
Yeah, I think that's all right. Yeah, go ahead, Lou.
Yeah, Spencer, Jackie was giving the perfect segue. So with that backdrop of the administration, the United States Department of Justice, what trends are you seeing at the federal and state level on non-competes and anything impacting healthcare specifically, like physicians?
Well, some states have enacted certain laws restricting the use of physician non-competes in some way or another, Colorado or Connecticut, Florida, for example. So we'll continue to watch that to see if more states pick up on that. And we'll also, of course, look to see whether the federal agencies like the FTC or other agencies are going to start taking a different view of these non-competes across industries, healthcare, et cetera. But I will add to what Jackie said that for healthcare industry employers, it doesn't work to just have a one-size-fits-all agreement that you try to roll out across multi-states. It really doesn't work in any industry, but not only do you have the issues of reasonableness of these non-compete agreements in healthcare, you also have these states enacting certain statutory language around physician non-competes, et cetera. So it's multiple layers that you need to consider. And so anytime a healthcare employer is thinking about using a non-compete for physicians or other healthcare workers, they really need to consult with counsel, look at the applicable jurisdiction, and customize the agreement as necessary.
And Spencer, does that get complicated in this new world where so many are working remotely? Which law will apply? Do you look at the employer, where the employer is, where the employees? What's your advice there?
Yeah, great question. And this is something we see all the time, is a dispute over which choice of law applies, which forum is the dispute going to be resolved in, and what if the parties have selected a state where perhaps the company is, but not the worker. So, for example, an employer is in a particular state and rolls out a non-compete for all its employees and tells them that they're all going to be having to resolve the dispute under the law of the employer's state. So courts will look at this based on a variety of factors. It's a choice of law analysis, and numerous things come into play. Looking at the different states, is there a conflict between their laws, or are the laws largely in harmony? Did the worker move between the states, or did the worker largely stay in one particular state during the time that they were working for the employer? What was the reason that the parties selected a particular state's law? Is there any reasonable or rational relationship to the parties or the dispute? So all these factors get looked at, but it is not the case that where employers can just simply say, well, we selected this particular state law and it was a matter of contract, and therefore the contract governs. And certainly the courts will apply the law we picked. It's just not that simple. So it's a multi-factor analysis.
So moving to our next topic, diversity, equity, and inclusion are areas that continue to draw a lot of national attention. My recollection is California took the lead on making implicit bias training mandatory. So Spencer, I'll turn back to you. Should healthcare employers anticipate more states following California's lead and making implicit bias training mandatory?
Yes, I think they should anticipate other states following California's lead. And I think it would be a good idea for them to go ahead and look to the existing California law on implicit bias training and either look to adopt something for their own organization and or update what they're currently doing in that regard. And just to kind of reset on the California legislature's thinking behind why they adopted these laws, they are looking at implicit bias in the healthcare industry, and they noted that it contributes to health disparities by affecting the behavior of physicians, surgeons, nurses, other healthcare providers, and that there's evidence of racial and ethnic disparities in healthcare that is remarkably consistent across a range of illnesses and healthcare services, even after adjusting for socioeconomic differences, insurance status, and other factors influencing access to healthcare. So I think other states are going to be looking at what California has done in this area and taking action, and it would be good practice for healthcare industry employers to be proactive in this area.
So as we draw near the close of our discussion today, I wanted to save a few minutes here at the end where I might open the floor to you both and see if there are any other developments that Spencer, either you or Jackie, or you would like to share as we wind up. So is there anything, open-ended question, anything happening right now to be aware of at a national level?
Well, there is certainly something that we've been watching on the employment front, which is the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, which President Biden has been adopted into law now. And so this is going to be a significant change for employers to adapt to. This law bans mandatory arbitration of sexual assault or harassment claims, as well as claims of retaliation resulting from complaints of sexual assault or harassment, and basically overrides the prior Federal Arbitration Act rule on these arbitration agreements, which allowed them. So employers are going to have to take a look at their arbitration agreements. They're going to have to update them and act accordingly. Certainly in the healthcare industry over the years, we've seen many claims of sexual harassment. Many of these have gone to jury verdict, and it is something that is critical for employers to be aware of, to be training on, to be taking all actions to prevent. But arbitration agreements have now been forever altered by this federal law, or at least forever for now, in terms of how employers need to be looking at them. So, and the other thing I'll point out is that in California, this law was also, a similar law was passed, and then it was expanded to other types of claims as well. So whether that is enforceable is up for issue in the courts, but it's something that employers are going to need to watch as a potential trend across other jurisdictions as well.
Jackie, how about the proliferation of remote workers?
I really wanted to take a minute to circle back to that. Thanks for asking, Lou. One of the things that we have often sort of addressed or struggled with in the healthcare environment, which I think is now much more universal in lots of employment spaces, is how to protect information, how to deal with data privacy, how to think about information that is protected as to individuals or the organization. And with remote workers having sort of the pace of remote work having accelerated over these last few years, I think that it presents some really unique challenges to think about how we protect information, both when we talk about activities in a bricks and mortar facility or office, or how that translates to somebody's desktop in their home office. And so I'm not sure we have time to, or that there's an answer today, but I do think it's something that we want to bring to everybody's attention to be thinking about, that as information gets shared in ways that were not contemplated in the past, we need to have some rigor around how we think about the sharing and the protection in that, in the course of that sharing and how that occurs. The other place that I think is still relevant, even as we start to feel like the pandemic winds down, is that a lot of our clients are still gathering or have left over lots of health-related information, some of which is protected under state law, some of which might be protected under federal law. There are distinctions between what we talk about as personally identifiable information and that which is protected health information under HIPAA, and we frequently talk about those federal protections and how they apply. Again, it's not something we have time to get into, but I do think that with employers, whether they are healthcare or not, having gathered information, whether it is logs of temperatures that they took a year ago, or whether it's rolls of who's vaccinated in their organization, there is a sensitivity to the information and there needs to be sensitivity as to how it needs to be protected. And so one of the things that we would caution is to make sure that you have the right protections in place, that you reach out to counsel about it, that you think about what both your state requires as to protecting this kind of data, as well as what federal rigors apply as we go forward, because I don't think that the way we deal with information in those either remote work environments or how we protect it where it's held is anything that's going away anytime soon.
Well, in closing our discussion today, I wanted to thank you both so much for sharing your time, experience, and expertise during this interesting and challenging time. I certainly enjoyed hearing about this information, which I know will be helpful for our clients in the employment and healthcare spaces as we move forward into 2022. Thank you both again.
Thanks again for listening to this episode of Working Wise, recorded in collaboration with Triage. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. If you have any topics you would like to hear about on the next Working Wise podcast, please send them to workingwise@klgates.com.